Good afternoon. If you're in the Eastern time zone, good morning to the rest of you who are joining us. We're glad that you could join us today. My name is Dan Cohen, and I'm the leader of Nelson Mullins' higher education team. Nelson Mullins is an AmLaw 100 law firm with more than 785 attorneys and government relations professionals across 25 offices in 11 states and Washington, D.C. Our attorneys practice in more than 100 diversified practice areas, including education and higher education, as well as government investigations and internal investigations. With a team of more than 50 education lawyers, former government attorneys, and seasoned litigators, the Nelson Mullins team has deep expertise and experience representing colleges and universities across the country in all aspects of their operations. That includes intellectual property and licensing and other revenue-generating streams, construction and public finance, privacy and information security, labor and employment, and other unique issues that colleges face, like student discipline, sexual misconduct, and intercollegiate athletics. Today, we're going to focus on some of those unique issues that are raised on that have been raised on college campuses by the recent Operation Varsity Blues scandal, which has been in the headlines for the last few weeks. Yes, it's an admissions scandal involving a number of highly selective universities. Educating students is what college is all about, but recruiting students to attend your school is obviously key, as we need students to pay tuition to enable us to offer all the programs and opportunities that we do offer. And the practices called into question by Operation Varsity Blues involve student recruitment efforts and involve fundraising, two aspects which are really vital components of what all of us do. So today's webinar, we want to elaborate on where Operation Varsity Blues draws that line, whether some of our common university practices now need to be called into question or reviewed, as well as some best practices to help ensure that not just this scandal, but also the next creative scandal hopefully can be averted on your campus. So this is our agenda for today. We're going to talk about Operation Varsity Blues, the criminal charges and the underlying scheme. We're going to talk about gifts versus bribes. Where is that line, and when could a donation potentially become subject to government scrutiny? And then we're also going to talk at length about lessons learned and best practices. What can colleges and universities do to reduce litigation and compliance risks, particularly in their fundraising and recruiting practices, in addition to their admissions practices? We also want to reserve time for questions. So obviously the webinar format is not as interactive as perhaps we might like, but we really do encourage you to submit your questions via the feature on your GoToWebinar platform. We'll do our best to answer your questions live to the extent that we can, and hopefully reserve some time at the end as well to come back to questions that we may have missed. If we don't get to your question, please feel free to email us. This platform will memorialize your questions in real time, so we will have those as well available. And we'll try our best to follow up with you afterwards if we don't have time to get to it during the webinar. So with that introduction kind of to what we're covering today, I'm very pleased to introduce Nekia Hackworth Jones. Nekia is a partner in the firm's white-collar defense and government investigations practice. She handles white-collar criminal defense matters, corporate internal investigations, government investigations, and complex commercial litigation. Her work spans multiple industries, including higher education institutions, as well as healthcare and financial services. Nekia is a 10-year Department of Justice veteran, working as both an assistant U.S. attorney in Atlanta and an associate deputy attorney general in Washington, D.C. And she knows something about attending highly selective universities, as she attended Harvard for both law school and her MBA, and attended Emory for undergrad. So with that, let me turn our program over to Nekia.
Thank you very much, Dan, for that generous introduction. And it really is an honor and a privilege to be here with you today to discuss Operation Varsity Blues. And thank you to all the attendees for today's webinar. Dan himself is a seasoned veteran in this space. Dan Cohen is the leader of the firm's higher education practice group, and he draws from decades of experience working with educational institutions and their athletic departments. Dan has actually counseled universities, colleges, medical institutions, and other educational institutions regarding Title IX athletics and sexual misconduct matters, athletics, strategic planning, NCAA compliance, litigation, labor and employment, school and university law, and sports law. I say all that to make it very clear that we are really very honored to have you here with us, Dan, to have this very important discussion. And we look forward to seeing the outcomes after we cover those topics that you've already identified here today. Operation Varsity Blues, this particular DOJ investigation has yielded incomparable media attention over the course of the past 4 to 6 weeks. Many individuals have different perspectives on the importance of this investigation and related prosecutions, but the goal of our conversation here today is to focus on what happened, how it happened, and most importantly for everybody on this call, what are the key takeaways? What are the key learnings and best practices that can be extracted from the staff, development directors, admissions directors, athletic department and staff who work in colleges and universities. So before we go down the road of discussing what can we learn, we wanted to just take a few minutes to discuss the underlying facts relating to Operation Varsity Blues, including the people involved and the underlying conduct. Many of the nation's top schools are involved in the Operation Varsity Blues scandal, and you will see some of the logos for those institutions on the slides in front of you. Much attention has been given to universities like the University of Southern California, UCLA, which is the University of California, Los Angeles, as well as Yale and Stanford, and Wake Forest University. But there is a myriad of institutions across the country, including Boston College, Boston University, University of Texas, and the University of San Diego, just to name a few that are also involved. There's been also much public and media coverage regarding Mr. William Singer, who was the lead defendant or is the lead defendant in this case. But we want to just take an opportunity to describe some of the other categories of individuals who are involved. On the slide in front of you, you will see Mr. Singer depicted here in the middle. He was the owner and operator of a college consulting organization called the Edge College and Career Network. And he was also CEO of a nonprofit, or I should say a purported nonprofit, called the Key Worldwide Foundation. The scheme, though, was only successful because of the individuals that he managed to pull together in order to perpetuate the admissions fraud that we have all heard so much about over the course of the past 4 to 6 weeks. First, in the top right corner, you will see a photograph as well as wording relating to athletic coaches and administrators. That category of individuals has gotten a lot of attention, as well as the test proctors and test takers who are working in Mr. Singer's direction, because both categories of individuals are essentially the insiders. These are the individuals who had the most access to, with respect to the athletic coaches and administrators, these individuals had the most access to colleges and universities. They had the ability to direct or to influence the admissions decisions among the nation's top universities. With respect to the test proctors and the test takers, these are the individuals who had access to the most commonly utilized college and university admissions tests, specifically the ACT and the ACT. These were also individuals who, through their own intellect and also through their different professional experiences, had become seasoned test takers and knew how to make high scores on exams. These two buckets of individuals are one of the primary ways or the primary mechanism through which the Operation Varsity Blues and the related scandal was able to be so successful. The third bucket you will see near the bottom right corner of the slide relates to the employees who worked for Mr. Singer's company, specifically the Edge College and Career Network, as well as the Key Worldwide Foundation. And essentially, these are the individuals who, working in the direction of Mr. Singer, would make contact with the other individuals who are depicted on this slide, specifically the parents who were essentially the clients or customers of Mr. Singer, as well as the test takers and test proctors, and finally the athletic coaches and administrators. And I've already made reference to them, but just want to make sure that we also give attention to the parents of the prospective college students. They are depicted in the bottom left-hand corner of your slide. And essentially, this is the money flow. This is the set of individuals who were essentially paying for different services, so to speak, that Mr. Singer would provide in order to get certain college students or prospective college students into the nation's top universities. With that being said, well, what is it that he did? What was the fraud scheme? What were the services that he was offering to these parents, customers, and clients? You'll see here that there were two buckets, two primary ways that this college admissions fraud scheme that is now known as Operation Varsity Blues was perpetuated. First, on the left, you see the test-taking fraud scheme, and on the right-hand side, you see the student athletic recruiting scheme. How did the scheme work? In the top right-hand corner, you will see that, first and foremost, Mr. Singer or individuals who would work with him at the Edge Company or the Key Foundation would strike deals with the parents who would learn about the services that he would offer. And I'm sure that it is not foreign to anyone who is attending this webinar that there are a myriad of college consulting companies, individuals who tutor students, individuals who assist high school students and prospective college students in readying their applications, making the applications as strong as possible to get students ready for college and universities and their very stringent selection processes. Well, of course, this is what Mr. Singer purported to do, just like any other college consulting company. However, he had a very unique set of skills that he would offer to the parents of prospective college students who would contact him. And usually he was put in contact with these parents through word of mouth. When he would speak with the parents, they would have explicit discussions about what the weaknesses were with the students who were seeking to get admission into these very selective colleges and universities. And depending on the needs of the student, Mr. Singer would work with the parents to devise either standing up one of the schemes or both of the schemes, specifically the test-taking scheme or the student athletic recruiting scheme. If ultimately the parent and Mr. Singer decided that the student athletic recruiting scheme was the most appropriate, and you'll see this at the bottom right-hand corner of your slide, Mr. Singer would discuss with his inside athletic department contacts ways to create fraudulent athletic profiles for the prospective college students. This would enable the high school student seeking admission to a specific college or university to have their names put on recruiting lists for that specific athletic department at that specific school. So one very popularized example is a rowing team, for example. If Susie had never had any rowing experience, never wanted to row, did not intend to row, but yet and still had decided that Mr. Singer and the parents had decided that this was the best way to increase Susie's likelihood of getting into college, Mr. Singer would work with an insider at a specific school, specifically an individual with the school's rowing team, to develop an athletic profile as well as an admissions recommendation, putting that individual on the recruiting list, such that once the admissions department saw all of those credentials, it would give Susie a leg up. It would give her a preference with respect to admissions consideration. That was one way that the scheme operated. The second way, for individual students that needed this type of assistance, Mr. Singer would work with parents to arrange for test scoring inflation. In some instances, the inflation would involve actually having a test taker take the test for the student. Sometimes it would involve having a test taker sitting in the room next to the student to change the answers. In some instances, it would involve having the test taker or a test proctor coach a student. If the student put down A and the answer was B, the test proctor or the test taker would direct the student to change the answers. But essentially, he would make arrangements for that student to go to a specific testing location so that his insiders, his test takers and test proctors could have access to that student in their test-taking environment. And unfortunately, almost on all occasions, in order to make that happen, the student's parents would have to work with the college board or the administrating organization for the standardized test to give the impression that that student had a disability. Finally, with respect to gifts and donations, and you'll see that at the top left-hand corner of the screen, in exchange for Mr. Singer's services, that is, in exchange for his ability to help inflate a student's test score and or his ability to help a student's name be put on a recruiting list for a sport they had no background in and or had no interest in playing, the parents would pay money at Mr. Singer's direction. Sometimes that would involve money being paid directly to athletic departments. Sometimes it would be paid directly to athletic coaches or organizations that were under their influence or control. And ultimately, these payments inure to the benefit of Mr. Singer in the amount of approximately $25 million, which of course he also used to pay himself and enrich himself, but also to enrich the other insiders who were assisting the scheme. Much of this, everybody on this call may have seen with respect to all the media coverage, but we'll just quickly make sure that everyone is on the same page with respect to the underlying criminal charges. All of the individuals have been charged with violations of federal law. This case is currently pending in the Boston Federal District Court. The conduct itself, as you saw when we covered the different schools that were implicated, the conduct spans the entire country. We're talking about students all over the country. At this point, there are approximately 50 defendants charged, and also the conduct covers a very large amount of time, 2011 to 2018. Additionally, and you will see on this slide just a quick summary of all the different players that we just discussed and all of the different charges that have been brought against those individuals and the way in which those charges have been brought. Our goal here was just to give you a sense of the seriousness of this particular scheme. And we fully appreciate that everybody here already knows this, but just wanted to sort of lay it out for you in terms of the severity of the different charges: racketeering conspiracy, honest services mail and wire fraud, money laundering conspiracy. And many of you may have heard that most recently there have been many developments in this case. Singer, the lead defendant, and many coaches have already pled guilty. 13 parents have actually already agreed to plead guilty and will be doing so in coming weeks. 16 parents have actually been indicted with a new charge of money laundering and/or money laundering conspiracy based on their intent to pay the fees charged by Mr. Singer in a way to conceal the unlawful source of the proceeds, to conceal the fact that they were committing a crime as part of the payment of funds. And most recently, and has gotten media coverage, I understand as recently as today, is the fact that some students, some adult children of the charged parents have actually received target letters. And target letters are often used by the Department of Justice to basically give a warning to individuals that they are under federal investigation, could be under federal investigation, and may face federal charges. Our understanding is that these letters have only been sent to individuals who were over the age of 18 at the time that they were students who received the benefits of this scheme. And also the DOJ only sent these letters to individuals where they had evidence that the students knew about this scheme. So they haven't painted a broad brush in this respect, but it does send the signal that they are continuing to investigate here, and this is something that they're not going to relent on anytime soon. All the individuals implicated in this case could face anywhere from 5 to 20 years in federal prison per offense. And the most telling thing here is that there really may be more to come, that this federal indictment is not the end of the story, that we could still be looking at additional things for the students, the parents, the athletic coaches, and even the institutions who are involved, such as state criminal investigations, Department of Education investigations. And our understanding is that there are several schools that are facing Department of Education investigations from the Office of Student Aid and Enforcement. Civil lawsuits, we know that at least one school has been hit with a civil lawsuit by current students stating that the value of their education has now diminished as a result of this fraud scheme. IRS and state revenue department investigations and audits, as well as legislative oversight from state and federal legislative bodies. I want to pause there and just see if Dan had any thoughts at this point. I wanted to see if you wanted to weigh in at all, Dan, before we keep pushing forward.
Well, clearly, this is all a signal that as the public scrutiny increases both governmentally as well as, of course, social media, the importance of trying to implement best practices, which we'll get to in just a couple of minutes, because these things can grow out of control pretty rapidly.
That's absolutely right. And to that point, Dan, one of the things we wanted to flag here, and this is really relevant to the rest of our discussion, is who got paid, and not just generally speaking who got paid, because we know that there are individuals who got paid in this scheme that are completely disconnected from the universities themselves. But focusing here on the university-related payments, specifically the athletic coaches and administrators, which you'll see at the top bullet on this particular slide, as well as the athletic departments themselves. Now, the first bullet for many might be clearer cut. The fact that you have individual coaches and administrators who are taking personal payments, either directly or through non-university entities, feels wrong. Even if you don't know the criminal statute associated with it, it kind of gives you that red flag internally that just does not feel right, that there is a payment going directly to a coach or administrator that can be tied to the admission of a particular student to a university or college. However, the second bullet, and this is where I think most of our discussion will take us for the rest of the webinar, is the payments to the athletic departments. And as I stated earlier, many of the payments that were made by the parents as part of this scheme were either paid directly to athletic departments, so just using an example, ABC University's rowing team or tennis team, or the payments were made by the parents through Singer's Key Foundation, and then the Key Foundation in turn would make payments to those athletic departments. The challenge here is that, there are so many people who make legitimate donations to colleges and universities generally, but also to athletic departments specifically on a daily basis, and they are completely altruistic. There is nothing untoward about those donations or gifts. But clearly we have a huge case here where there was a problem. And the question is, how difficult is it for a university or college to detect this on the front end? What, if anything, can a college or university do to minimize the risk or eliminate the risk that something like this can happen without them detecting it on the front end? And so this pivots us to the second part of our discussion today. As Dan teed up at the beginning of the webinar, gifts versus bribes. Where is the line? Is there a line, and where is the line? There is commonality, interestingly enough, between a gift and a bribe, because they both relate to something of value, whether it's money, stock, a promise of money, stock, real property, personal property, some other benefit. Both a gift and a bribe start off with a similar nexus of something of value, either goods or services that are given. Where they diverge, though, is the intent behind the thing of value that is given. With respect to a gift, and I'm sure that many of us on this, on the call, on the phone, who are participating in this webinar have made donations to very worthy causes. And usually when you're giving a gift, even if it's to a family or friend, but certainly to a nonprofit organization, you have no expectation of getting anything in return. So if you donate, just using an example, if you donate to the Atlanta Symphony Orchestra, you don't necessarily expect anything in return. You might get a nice kitchen magnet, you might get a nice pen or pencil, something de minimis, but there's not a full expectation of something in return. But that is substantively very different from a bribe or a kickback, because the item that is given, that thing of value, by the person who is giving it or by the person who is receiving it, their intent is to either obtain or give something that is wrong. And usually it's for the purpose of improperly obtaining or rewarding favorable treatment. And in this specific case, when we're talking about college admissions fraud, the favorable treatment represented or manifested itself in terms of admissions points or preferential treatment in the admissions process. Now, we know that things like the intent of an individual can be very, very difficult to prove, but we wanted to share with everybody on the phone today that even though difficult to prove, it is really the key consideration in figuring out whether or not something was just a gift or whether it was something more illicit or insidious, like a bribe or a kickback. Knowledge and intent of the parties who are involved in the transaction really are the key factors that I can tell you government regulators are going to look for, government agencies, law enforcement officials, all of the individuals or entities that care about these types of transactions. That's what they're going to look for. Now, it's hard to know what is in the mind of any individual. However, usually what a law enforcement officer, like a federal prosecutor or the FBI, usually what they're going to look for is some external manifestation of the party's intent. Well, instead of using it in the abstract, let's take that and apply that to the Varsity Blues case. What could have been some of the things that were problematic here? How can the government, or how will the government prove the intent of all the parties who were involved? Here on this slide, you will see some of those specific circumstances. Well, with respect to the parents, the intent of the donors and the payers, their intent was to obtain school admission for their children through fraudulent test scores and academic credentials, and also the intent of the donees and recipients, such as Mr. Singer, the athletic coaches, the testing professionals. Their intent was to facilitate fraudulent school admission. Well, we knew that everyone knew about it because if you read some of the documents or if you follow the media reports, there are transcripts where they're talking about how they're going to perpetuate the scheme. There are explicit paper trails that show money being transferred. There are documents that memorialize the fact that there are athletic profiles that are being fraudulently generated. So you have a paper trail that confirms the external manifestations of the intent of all these parties. And finally, as we then pivot back to Dan to get some of his fantastic insights here, what were the gaps that were exploited here? Again, it doesn't mean that any of these things are wrong, because athletic admissions and fundraising development operations happen by fantastic people who are doing the right things each and every day. But what were the parts of the system that these specific bad actors were able to exploit? And what, if anything, can we do to potentially either close those gaps on the front end or mine those gaps going forward? With respect to athletic operations, one of the, or three of the ways that the bad actors were able to exploit the athletics department was a lack of independent verification of the students' athletic credentials, the fact that some of these coaches had outside employment and or affiliations that the universities either did not know about at all or didn't fully know about, and the lack of periodic audits regarding why it was that certain student athletes either didn't join the team or left the team fairly early in the season. Secondly, looking at development of fundraising operations, a lack of tracing or tracking of donations to admissions and student athletic recruiting efforts, put simply following the money to see if there were certain benefits or treatment that seemed to follow money trails relating to a specific student. And similarly, admissions departments looking at the fact that there may have been a lack of independent verification of a student's athletic credentials, and similarly, as I already stated, tracing or tracking donations to fundraising and development efforts. I'm very fortunate again to have Dan here today because he's lived in this world for decades, and want to give him an opportunity to share his insights relating to not just Varsity Blues, but the path forward for colleges and universities.
Thank you, Nekia. Excellent description of kind of the lay of the land, what we're all looking at. You know, it's one thing to have it filter through social media where it's just too easy to, you know, whatever, make fun of rich people. But really understanding what this means from a DOJ perspective, and then how we translate that to best practices on campus. So it's important also to note, I think, that, you know, everything right now is alleged. While there may be, you know, paper trail or a money trail, there are still legitimate legal questions about the extent to which it was wrongful. So I think right now the answer is a resounding maybe. But I think from a university and college perspective, what we really need to note is the level of scrutiny being delivered right now to these institutions based on the wrongdoing of a handful of individuals. All of us want to avoid this type of scrutiny. And so regardless of whether these alleged actions are true, regardless of whether, if true, they are wrongful, y'all don't want to get into this position. I mean, that's really the bottom line, and why we wanted to take the time today to kind of discuss this with you. The other thing that really caught my eye about this, again, I don't want to, you know, just kind of go in the social media direction and make fun of rich people. This is so much of this behavior actually is relatively close to business as usual for a lot of us, and it's being called out in this case. Do we need to worry about when a donation could become subject to government scrutiny? So let's also talk about a little bit of context, right? Like, first of all, how did we get here? Well, we've had decreases in state funding for higher education for a number of years. Really since the economic downturn of '08, it's been quite pointed. And so schools have come to rely more heavily on fundraising efforts across the board, tuition efforts, enrollment management projects, programs, so that we can try to recruit and retain tuition paying students, because we need that money to keep the lights on, to develop the programs, the educational programs from which our students benefit. Similarly, athletic departments are heavily dependent upon donations, particularly some Olympic sports that do not have as much revenue potential as, say, football or basketball. According to the indictment, Singer, his agents, the affiliated coaches, and the parents really work together to exploit those types of angles. So if we are in a culture, which we are, where Olympic sports are largely living on donations, we really need to be cognizant of where those could potentially become wrongful. You know, when should a school question a donation from the parent of a student athlete to the athletics program? But also, let's again take a step back, because in this particular case, such efforts to scrutinize parent donations, frankly, would not have caught even many of the payments that are described by the FBI. Singer allegedly routed the parents' payments through his Key Worldwide Foundation in order to avoid being easily tracked back to those parents. Donations can also come later, after the admissions decision is made. It doesn't make it less wrongful, it just means that they gamed the system a little bit more creatively. So as we're talking about best practices and implementing key controls, internal audits, what we're looking for is the sense that we're proactive, that we're trying to stay on top of and anticipate potential issues, whether this issue or some future creative issue. But let's also talk about, still on context, you know, the lifeblood of colleges and universities, it's recruiting, but in the athletics context, it's also walk-ons. Is it fair to question schools' walk-on practices? You know, we've got walk-ons or non-scholarship athletes on rosters throughout the country, on many, many teams. At a certain level, perhaps the government is now making us ask why. Clearly, most are there for the love of the sport. Oftentimes, they'll be there even if they're not going to make the starting lineup. But we have some student athletes who also realistically, you know, may not have the talent to play as much as the starters. You know, that 15th student athlete on the end of the basketball bench, maybe that person just wants to be a coach in the future. And if their parents happen to be benefactors, is that now a problem where someone, of course, they're participating and helping in practice, you know, pushing the starters to get better. But if they're really there not based on talent, but they're on the end of the bench based on their desire to be involved in the program and become future coaches, and their parents are benefactors, is that a problem now? From a recruiting standpoint, are athletic administrators now supposed to question embellished, or if not fabricated, at least embellished high school athletics qualifications? Can we no longer defer to coaches to make those assessments? Well, maybe we can't, at least in a silo. Stepping outside of athletics, what about the all too common embellishments that we find throughout high schoolers, you know, non-athletes, but high school applications? I mean, there's embellishments everywhere. It's probably ubiquitous. So how do we draw the line of what it is that we're supposed to question, and how do we go about doing that? Because we're certainly not going to, we're no longer able to turn a blind eye to it, but we also cannot realistically audit every single applicant, every single recruited student athlete, whether walk-on or scholarship, to see if there may be some nefarious wrongdoing in the background. Again, we're dealing with a tiny, tiny, tiny fraction of people who are trying to do wrong. But if you happen to find yourself within that tiny fraction, if you're the university, you've seen the amount of negative scrutiny that's come via social media, via mainline media, and of course, via governmental investigation. One other thing that we wanted to talk about here is also the special role that rowing plays in college athletic departments. Rowing walk-ons with no rowing experience are common. There are more female NCAA rowers than there are high school rowers. You know, the public may not understand that a lack of rowing experience is not a disqualifier at all from participating on a varsity NCAA rowing team. Typically, they'll come in through a novice program where they will learn. They probably will not be scholarship. Many will drop off of the team. That is common, and it's not the slightest bit nefarious. But now we have to realistically ask that question. Well, what if one of their parents gives a donation? Do we need to be suspicious? Are they saying that they want to be a rowing, join the novice rowing program because they want to get admitted? And what if the parent has paid in order to kind of, grease the wheel a little bit and help to get them admitted? That's a question that I think that we realistically need to be asking now. We'll get into that in just a few minutes as we kind of walk through some best practices with specificity. Another line that has been drawn publicly is about walk-ons dropping off of teams. Well, that's another reality on college campuses. Sometimes it's just not worth the amount of effort that it takes. If you're on a rowing program and you've got practices at 5 a.m. or 6 a.m., that's a major, major commitment. If you're also, especially if you're a walk-on, not only are you concentrating on your studies, but you're also perhaps having a full-time or a part-time job in order to try to make ends meet. Lots of walk-ons choose to drop off of teams. So non-participation in the athletic activity that you initially expressed interest in, I mean, that's not a realistic measure. But we can't be blind to the signs that it may suggest something else is going on. These things probably are not problems. Most of the time they will not be problems. But the point, one of our macro points here is that we can't assess them. We can't analyze for patterns to try to root out potentially wrongful behavior. We can and probably should audit the frequency of walk-ons dropping off of a certain team's rosters and ask questions why. Maybe not for every single person. Maybe we don't have enough resources to do that. I'm sure we don't. But we can make proactive efforts to try to detect whether we may have potential legal or compliance issues. So with that, we're going to turn to a hypothetical, or actually two hypotheticals. We want to play this out a little bit more. So in our hypothetical, we have a wealthy and famous parent named Dory Hoffman. Dory's daughter is a preferred walk-on to the USC rowing team in this hypothetical, and she's admitted to USC in part on that basis, the fact that she would want to be a member of the USC rowing team. This individual has no prior rowing experience, and then she joins the team. She practices, but she's not good enough at this point in time, being a novice rower. She's not good enough to compete in NCAA races as a freshman or as a first-year student. Dory Hoffman, the mom, then donates to the school rowing program. And then fast forward, the daughter ends up leaving the team after that single season. So with that predicate, this hypothetical, I want to turn it back over to Nekia to talk about whether or not this conduct, which may be common on some of our campuses, is this wrongful, Nekia?
Well, I've got to tell you first, Dan, I've learned more about rowing, I think, in the past 4 to 6 weeks that I have in my entire lifetime. And here it's probably the famous lawyer answer of, it really does depend. I think in many situations that the risk of criminal or civil liability is really going to turn on, yet again, what we talked about a few moments ago in this webinar on intent and knowledge. If the staff of the university, whether it be admissions, fundraising development, in the athletic department, as well as the parents and the student, if they do not orchestrate a plan on the front end, if they do not create a ruse by which Dory's daughter is going to fake or feign interest solely for the purpose of getting into this school, then the risk of criminal liability and civil liability for the institution and the staff is probably pretty low. Where you will get into a tougher time and where you're closer to the varsity blues line is when you have either documents, witnesses, or other evidence that the daughter's participation interest and or her decision to quit was orchestrated by these insiders, by these major players. Again, individuals who are connected with or who work with the university, working in concert or in coordination with the daughter, Dory herself, and Dory's daughter, in order to facilitate the daughter's admission. Again, this is easy to say in theory, but it can be hard to detect on the front end. But that really is going to be the operative piece of whether or not this is a problem. Who knew what and when? Timing of the knowledge and intent piece of all the players involved. Now, if we change it up a bit, I'm curious what you might think, Dan, if we have just a slightly different hypothetical. It's exactly as you stated. You have Dory and her daughter. She's a preferred walk-on for the rowing team without any prior rowing experience. She gets into USC in part on that basis, but instead of practicing and then kind of dropping off because she just wasn't good enough at the start of the season, she never practices, but instead she does make a contribution to the team, but in this instance, through the position of being a team manager. She's essentially converted from being a rower to a person who was helping with the operations of the team as a manager. The rest of the fact pattern remains the same. Dory still donates to the rowing program, and ultimately the daughter decides to leave the team altogether after 1 year. What do you think, Dan? Does that change the analysis here at all?
Well, I think that we're still going to have a relatively low risk of criminal or civil liability to the institution and its staff if they don't have any advanced knowledge that the daughter will be converted into a manager. If this is just something that plays out organically and legitimately, based on what I know, that wouldn't necessarily suggest a problem. But if they do have knowledge ahead of time that this conversion will occur, in other words, the recruitment process was not all on the up and up, this person was not going to be a rowing student athlete despite their promises on the front end, then that could increase that otherwise likely low risk of criminal or civil liability. If we're instead talking about, knowledge by the staff, then we're probably going to have a moderate to high risk of criminal liability, as well as civil liability of the institution if the daughter's decision to quit the team was not only kind of premeditated, but it was also orchestrated by the school, the staff, or the parents. At that point in time, they are trying to deceive the school collectively in order to engineer an admissions decision based on the facts that we're presenting here in this hypothetical.
Thanks very much, Dan. These are really tough questions. That's why we're talking here today, because few scenarios will be black and white. The black cases and the white cases are the easy ones, but based on our collective experience, I think we would agree that 99.9% of the cases are shades of gray. So we want to do what we can to guide everyone today in thinking through lessons learned from the college admissions scandal, and most importantly, for the daily work, the fantastic work that each and every one of you do every day, best practices that you can take back to your organizations so that you individually and you collectively, being an employee of larger organizations and institutions, never have to go through this as these various schools have through the college admissions scandal. We've spent a lot of time talking about the athletics context, and it's relevant because that is what was put under a spotlight here. But we also can guess that many of you have seen the popular social media meme, which has been, well, why didn't the rich parents or the celebrity parents who were charged in this scandal just donate a building like everyone else does? And in fact, the U.S. attorney who is in charge of this matter up in Boston actually said during the press conference when he announced the results of the Varsity Blues investigation, he said, we're not concerned with building donations. That's not what we're talking about here. We're talking about bribery and kickback. So he even explicitly carved out these building donations. And we do agree that there are, we said it here before, that there are people who make very high dollar value donations for truly altruistic and philanthropic reasons. The estimate on charitable giving to colleges and universities for 2018 was $46 billion with a B. And so you have a lot of charitable giving that comes through higher ed institutions. But realistically, and I'm sure that many of us have either seen it in our professional experiences or maybe even our personal experiences, there are people who make those high dollar value donations who perhaps hope for, they desire, or they expect to influence admissions decisions or other decisions. It might be grades. It might be a particular award at graduation. It might be placement in a highly selective honors program. We can think of all types of examples of benefits, accommodations, preferential treatment that individuals might want or expect in exchange for multi-million or billion-dollar donations. Are all of these things now questionable? And again, the answer is potentially. At this point, this scandal has placed everything up for grabs, and anything can now be under the spotlight. From the institutional perspective, we're talking operations, internal audit, policies, and procedures. From the staff perspective, we're talking about the same units and divisions that we've been speaking of throughout this webinar, specifically admissions, fundraising, development, and athletics. Parents and donors, and what you as a parent or as a donor to an institution might do or might not want to do, as well as students and how your application can be viewed and what you put in that application. Again, what can schools do to guard against having their fundraising efforts and their recruiting efforts questioned by the FBI, Department of Education, or to avoid civil lawsuits? What are the best practices here?
And I'll add one thing real quick here. So while the prosecutors in Boston did not say that they were currently concerned with a situation where a wealthy donor is donating a building, perhaps that's not fraud. No one is defrauded in a scenario in which everything is open and honest. We are giving you a large donation, and in return, we expect some preferential treatment. 50-yard line seats, whatever the case may be. That's all out in front. But what we're finding as a result of this case and related, kind of how this could play out in the future, the question really arises, are influential donors at risk? And in turn, are our fundraising practices subject to increased scrutiny? I think, as Nekia was suggesting, if this slides from an admissions decision, okay, maybe that level of influence is expected, to now, Johnny or Sally's expected to get straight A's, and the professors should know who Johnny or Sally's parents are. That could be opening doors. So again, it does require some internal auditing or internal control functions in order to keep an eye on these types of creative developments.
Absolutely. Lessons learned here are, and Dan said it, let's keep an eye on these things. Risk mitigation. I think there's an adage that says an ounce of prevention is worth a pound of cure. And in this scenario, that is no exception. Some of the justifications or minimizations that I know I've seen in my time as a federal prosecutor, and I'm sure that Dan has seen in his deep experience working with higher institutions, is that it can be easy to say, oh, that's just one little isolated thing. That's just one bad actor. Oh, that's just a small thing, no big deal. That person siphoned off $1,000 while our endowment is $1 billion. So we're not concerned with that. We're hopeful that this college admissions fraud scandal and all of the related outcomes from it have driven home the point that there is no such thing as a little investigation, just one bad actor, or an isolated or contained problem. Any and every instance has the potential to balloon in a way that can be catastrophic, impacting an institution's reputation, their fundraising, and their recruiting abilities. And Mark Twain said it best, that the public is the only critic whose opinion means anything at all. And reputational damage, honestly, is, out of all of these things, is the most difficult to repair. Reputation determines, in large part, whether or not organizations and individuals want to give to your university, whether or not they want to attend your university. And so that reputational damage will adversely impact fundraising and recruiting efforts. I want to quickly do a baseline here. Before we get into some of our personal recommendations and best practices, I want to share with this audience a baseline that, unless you are sort of in the world of corporate government investigations and prosecutions, you may not be aware of. Starting back in 2004, the United States Sentencing Commission, who was responsible for giving guidelines on how individuals and corporations who commit bad acts should be sentenced, developed a guideline specific to compliance programs and organizations. And many on this phone may remember that back in the early 2000s, we had a spate of just corporate misconduct, from Enron and WorldCom to many companies we may have never even heard of that were prosecuted and people held accountable. So as a result, through the United States Sentencing Guidelines and the work of the United States Sentencing Commission, and you see that resource on your left-hand side, there's an image there for you. From that, the organization developed 7 elements of an effective compliance program. And I don't think any of these will be earth-shattering or brand new to anyone on the phone, but just wanted to share this because essentially this is the baseline for the federal government, and private compliance programs, professional organizations, compliance officers, from chief compliance officers all the way down to analysts, develop their programs in part based on what the federal government wants to see. And this is a thing, if you look at these 7 elements, if your program follows and incorporates these 7 elements, if the FBI comes knocking, if the Department of Education comes knocking, this can be some cover for you. It might not completely eliminate or mitigate the problem, but you can say, we have at least done these things that the United States government has said we should do, and that will usually be very helpful to you. I want to go ahead and now turn to the best practices, because I want to make sure we have time to cover this very helpful information. And so I'll turn it back over to Dan.
All right, so I think, you know, we've said it here, but people are always going to be creative. We may be able to safeguard against this type of admission scandal now that we know about it, but there's another different scandal right around the corner. So what we want to really focus on are how to build best practices to not only protect ourselves from this situation, but others like it that we maybe haven't thought of yet, but somebody out there with an intent to deceive, somebody's already thought of the next one. Further, it's not just the social media and the reputational hits. The FBI has now illustrated a propensity twice in 2 years to go after conspiracy cases involving college athletics, following on the heels of the college basketball investigation last year. There's tremendous scrutiny on college athletics these days, and future enforcement efforts by governmental regulators will probably continue to be robust. So we want to talk about universities and colleges taking proactive steps to address potential issues, because instances of perceived bribery largely seem to circle back to a concept of perceived inadequate institutional controls. And those lack of institutional controls can have severe consequences, reputational and otherwise, as we've seen. So what best practices can we implement to try to avoid these types of situations? So again, we've kind of mentioned, well, let's start with the first one. We've kind of mentioned before, we may not have institutional resources to cover every single situation, but so SpotCheck may be the name of the game for a lot of us. In this admissions scandal in particular, coaches who allegedly took bribes appear to be lone gatekeepers based on the charging documents, or if not the coach, then the administrator maybe was involved with knowledge of the plan as well. So universities would be well advised to have a second person from the school's compliance or admissions department do due diligence on an applicant, if we're looking in particular at this admissions scandal, to check if there's anything suspicious, such as a parent donation to the school, to conduct some due diligence on the student's athletic credentials and qualifications. Maybe they want to do a spot check on, go out to a practice, see if the student's athletic abilities match up with what was suggested. Now, of course, we need to always defer to our coaches on these types of situations. We're not suggesting anything otherwise. But to have a second set of eyes outside of the silo, to have NCAA compliance looking at athletic qualifications perhaps, or having the admissions office do a double check. It's people from outside. It's really about cross compliance, I think, is the word that we use in this presentation, the PowerPoint, so that others can, for example, see if someone who was on the team but then left, whether they left under suspicious circumstances, whether it was a claim of injury. Okay, was it that legit? Did this person actually get hurt? A phone call can sometimes be simple enough to follow up and make sure that they left the team for that reason. But increasing the institutional audit function or the compliance function across parts of campus that may be susceptible to exploitation of bad actors. Don't allow a coach to operate solely in a silo. Have the sports supervisors involved, have NCAA compliance involved, have perhaps institutional audit involved. And this goes all which ways, right? A lot of these are admissions decisions that we're talking about. So make sure that somebody from the NCAA compliance world is plugged into the admissions decision in the admissions office as well. It's kind of cross-pollination, making sure that there are different eyes, again, on a spot check basis, but so that we don't get too isolated in our decision making where bad actors perhaps could roam free potentially. Policies are also a huge part of this. Certain schools have expressed policies that prohibit admissions that are motivated by concern for financial or political or other benefits to the university. Other schools may not go that far, but having a broader review of those potential patterns for donations by the families may pick that up. You could have a policy restricting when donations could be accepted. Perhaps you want to have a policy where a donation could not be accepted from the family of a prospect, and you have to wait until that student or student athlete is enrolled before you could accept that donation. Now, the promise of the future $500,000 donation, contingent upon admission, yeah, you're not going to catch that one, but at least you can show the governmental regulators that you had a program in place that would have hopefully caught most wrongdoing. You can't catch everything. People are too creative if they really have an intent to do wrong. Of course, there's the educational component. You have to train and educate key employees and administrators on compliance matters, not just NCAA compliance, although NCAA compliance administrators are crucial in these athletic-related efforts, but you also need institutional compliance concepts, right? Employees and administrators who are involved in the fundraising world, in the recruiting capacities. We need some cross-pollination so that we are holistically, as a university or college, looking and trying to build in safeguards so that situations don't get too isolated where one wrongdoer can take advantage of systemic gaps. Educating athletic department staff, fundraising staff, recruiting and admission staff about those policies, such as when donations can be received from a prospective student athlete's parents. Educating coaching staff, development staff, prohibiting discussion of donations prior to admission. Maybe that's a policy that you want, just to prohibit even discussion of donations prior to admission. Now, how are you going to catch that? Well, we've got folks on campus who can potentially help with doing that. If not in every case, at least having policies and procedures in place to try to spot check and catch them when you can.
And Dan has well covered the idea of creating a culture of cross-compliance. We know very well that everybody on this call is a part of an organization that has a culture of compliance, but really building out cross-compliance, as Dan explained. Also, conducting internal investigations where and when necessary. I know that I am steeped in the world of internal investigations, as is Dan, and we realize that they can be resource intensive. They do take time away from your daily operations, but the dividends and benefits are worth the investment of resources, because internally you can identify whether, when, and how an issue, a problem, whether it be an institutional problem or a lone actor problem occurred. And you will also have that in certain instances, depending on how and whether you decide to disclose it to government regulators. You can share that with the regulators to say, hey, we identified this issue early on, and here's the investigation we conducted to resolve and solve the problems. Enforcement. Enforcing the institutional policies that Dan already alluded to, because anything that's just on paper that's not enforced basically has no weight. So if there is a policy that restricts conversations about donations with respect to the timing of admissions decision, and you catch someone doing what they're not supposed to be doing and violating your institutional policies, that person needs to be sanctioned. And of course, and most obviously, enforcing and following federal and state laws, and again, sanctioning bad actors that violate these canons. Finally, document, document, document. If it happened and nobody can prove that it happened, it's as though it didn't happen. So you want to make sure that you're documenting your practices, your protocols, your procedures, and your findings. And it doesn't mean you're going to disclose and turn everything over in every instance, whether it's, a regulator necessarily just asking for it, or whether it might be a parent, or whether it's just a curious individual asking for a particular paper trail. But you definitely want to have that internally, so that if and when you are required to turn it over, or you want to use it to your benefit, you have that documentation to fortify your position. And again, I didn't cover the 7 elements of an effective compliance program on the prior slide, because essentially these best practices closely track those 7 elements.
Okay, so I know that we're running low on time. I think that it's now 1:30 Eastern, so we'll wrap up with this slide. We do want to thank you for the questions that have been coming in. I know that there was one question about, I guess, the presentation slides themselves. Yes, we will email those out to all the folks who attended this presentation. The last slide that we want to leave you with is the idea of analysis. This is not as much of it relates to internal audit, but you can have departmental employees conducting analyses of trend lines across the board. And this is another best practice that we would recommend. For your admissions office, are you following your written admissions criteria? If there's a notable amount of exceptions, do those exceptions follow a trend? That might suggest that you have a bad actor somewhere in your process, but it may also just innocently suggest that perhaps it's time to reevaluate and change your criteria. Perhaps you're veering in different directions for a reason. Or maybe it just means that you need to redouble your efforts to be consistent, to follow your own criteria. But doing that kind of analysis of trend lines with admissions decisions is something that you should be doing holistically on your own anyway. Same thing with fundraising, right? Reviewing your fundraising numbers, your trends. Is there anything suspicious occurring with fundraising over time? In the current world that we're talking about with Operation Varsity Blues, you want to look at parent donations, prospective donations. Now, at a certain point in time, you're going to bump up against legacy donations, people who've been giving for 20, 25 years. Well, guess what? Or whatever, 17 years, and now Johnny or Sally's ready to go to school. Do you have a history and continuing practice of giving that makes you not question when Johnny or Sally is now applying for admission? Or is there all of a sudden a spike in the amount? Well, perhaps you should ask a question if you're seeing that. Again, just an analysis of your trend lines is going to help you. In athletics, analyze your squad lists, again, for trends over time. Are more students quitting or getting cut from one team? In the current admissions scandal, perhaps that would flag that the coach was permitting underqualified student athletes onto the team, in which case you can investigate why. The vast, vast majority of the time, you're not going to find anything nefarious. You're not going to find anything criminal or even potentially criminal. But, if you're analyzing your trend lines and asking why student athletes are leaving one particular team, perhaps it will suggest other cultural issues to you. Perhaps a coach is driving away student athletes that you would nonetheless want to address. So this type of internal analysis, taking a step back and looking at the data that you have, can be very, very helpful. In light of the current climate, we would recommend looking at if you're doing a squad list analysis for trends, we would suggest looking at walk-ons first. That might be an area that's going to be more ripe for questions publicly. Are there recruited walk-ons who got admissions priority and then left the team early in the year? But again, with the creativity demonstrated by this case, the Operation Varsity Blues case, we can also anticipate that there's got to be other possible schemes out there, right? Maybe the next admissions case, instead of involving parent donations, involved kickbacks from a scholarship athletes funds for a student who otherwise wouldn't have been admitted into a chosen school. And now coach is saying, yes, I will give you a scholarship, but in fact, you're actually going to give me that scholarship money back. I don't know. I'm not a criminal mastermind, as much as I wish I were sometimes. But we do try to anticipate what might be around the corner. And so, again, these kind of squad list analyses can potentially reveal trends over time. So again, we do want to be respectful of your time. I know we've run just a couple of minutes over. Our bottom line here is the status quo is no longer an option. We really do recommend implementing some of these internal controls. And with that said, in the interest of time, we want to thank you for your questions. We are sorry that we didn't get to all of them, but we want to encourage you to please feel free to follow up with us after this webinar. You've got Nika's contact information there. You've got my contact information there. So if you have questions about this topic, or frankly anything else that Nelson Mullins may be able to help you with, any other legal needs, legal questions, please feel free to follow up with us. Thank you so much for your participation this afternoon. We appreciate it.